The Senate spokesperson, Senator Ajibola Basiro, joins us from our Abuja studio to clarify some of these issues for us. He's also a member of the Constitution Amendment Committee. Thank you so much, distinguished Senator, for joining us tonight. Give us a sense of what, because in your statement today, you said it's not as if you're creating a state, but it's part of the proposals and the propositions. But how strong is the proposition to create more states in Nigeria?
Yeah, thank you, Seun, for giving us the opportunity to make that very important clarification. When I woke up to a screaming headline on one of the national daily that the Senate proposes creation of 20 states and made reference to INEC, I was shocked because that never occurred at the recent retreat of the Senate that was held over a 3-day period and which I participated. The issue of state creation is not just about constitutional amendment. You will know that the provision for amendment of Constitution generally is provided in Section 9 of the Constitution 1999 as amended, but specific peculiar provisions are provided for creation of state and local government in Section 8. So, situation we have on hand is that we must make a distinction between Section 9 amendment and Section 8 amendment. Even Section 9 amendment is in twofold. When the amendment relates to Chapter 4, which as it is about fundamental rights of the Constitution, you will require 4/5 vote of the National Assembly in the two chambers, but any other amendment will require 2/3. In relation to creation of the of new states, Section 8 envisages 4 very important positions to occur concurrently for us to even be talking about a bill before the National Assembly being competent to be considered for state creation. And that was the essence of the clarification I had to make. First and foremost, the Senate is not making proposition for creation of any state, whether 1, whether 2, whether 20, or whether any number. What has happened was that there were requests for creation of states, and the Senate is not in a position to even make that proposition until requisite provisions of Section 8 are complied. And what are these provisions? 1, the request for creation of state must be supported by 2/3 of elected representatives in the two chambers of the National Assembly and the House of Assembly from the areas from which the state is to be created. Secondly, the request must be supported by 2/3 referendum of people in the area from which the state is to be carved out. At the same time, even after the referendum, the people in that area must also agree. Then you are also talking of 2/3 resolution of the two chambers of the National Assembly. So before you even talk about National Assembly considering whether to give assent to creation of state, the first requirement of the request being supported by 2/3 of elected people within the confine from which the state has to be created need to be passed. I'm not sure that threshold has even been passed. Assuming that threshold has even been passed, the INEC has a role to play, and that is in conducting referendum, and the referendum must be supported by 2/3 of the people within the area that has been created. And if the way the Section 8 is drafted, 2/3 appear to be general, not those who actually participated in that process. So as far as we are concerned, the Constitutional Amendment Committee of the Senate has not made proposition for creation of any state. We have only made reference to INEC to go and consider whether there have been proper case for us to even begin to talk of a consideration of creation of a state. So that clarification is very necessary because the issue of state creation will have to look within the parameter of even the challenge and efficiency of a governance structure in Nigeria. There are schools of thought that even thought the IC state structure is even too large, but without prejudice to the fact that Nigerian Constitution creates facilitative provisions in Section 8. As a National Assembly, we cannot deny people from making the request, but that request must pass the necessary threshold, procedure, and lay down rules in Section 8 of the Constitution.
If you look at the last time the creation of state was done in Nigeria was around 1996 or 1997 when we got to the 36 states. 1991, it was about 30 states. And 1987, I think that's when we were 21 states. In 1976, we had about 12 or so states. And I mean, 1963 was just about 3 regions of the country. In 1960, it was the northern, the eastern region, and the western region. And we have come to this point. I was at some of those hearings when some groups, I heard the one from Ibadan for the creation of Ibadan State. I heard the one from Ogun State where there was a motion to create an Ijebu State. But these are, if you listen to these people who brought about these motions and these propositions, they have genuine interest and genuine reasons for wanting these states to be created. But at the retreat that you had, a 3-day retreat, when this matter came up, how did it go?
At the retreat, you see, there's a difference between people having genuine concern, that's those who are the promoters of those states. There's a difference between whatever their motive is and whether they have complied with the provision of the Constitution. The Senate committee availed itself of services of legal scholars, political scientists, and economists in discharging responsibility. And at the retreat, all these consultants engaged by the Senate actually also participated actively. When it comes to the point of the issue of state creation, simple question: what is the procedure? Section 8 of the Constitution was looked at, and as far as we are concerned, the position of the committee is that we cannot even proceed because we have not seen evidence of a request supported by 2/3 of the legislators within the confines of states requested to be created. Evidence of that was not before us at that time. We have also not seen evidence of support of 2/3 referendum affirmative to the creation of those states. So with those two prerequisite, mandatory prerequisite in Section 8 of the Constitution, the Senate committee merely deferred the matter that we cannot begin to consider that until we are satisfied as to the evidence of those requirements. This is not to say that one is either in agreement or disagreement of those who are the promoters, but we are sworn to uphold the Constitution. Section 1, subsection 3 of the 1999 Constitution are comprised of the provision of inconsistency. Any act or law inconsistent with the provision of the Constitution shall, to the extent of the inconsistency, be null and void. So we cannot begin to talk as a National Assembly that want to create a state when the requisite mandatory provision of Section 8 up to the level that it will even properly come before us has not been complied with.
There was an agenda before the Constitution Amendment Committee when you started off in this 9th Assembly on the issue of constitutional amendment. Was state creation part of that agenda?
Of course, when we talk of creation, amendment of Constitution, it's not just National Assembly that will set the agenda for it. And that's why, as a body, we will receive memoranda from different parts of the country, from different sectors, different age group. We also have senators who are interested in making certain aspects of our Constitution to be reformed, and they introduce bill. Personally, I also have cause to introduce some bill on constitutional amendment. Of course, the public hearing and the opportunity to throw in a memoranda before us also came up with some requests for state creation. But the question is that it's not just enough for there to be a demand for creation of state or insertion of certain reform in the Constitution. The requisite provision of the Constitution must be complied with. I said, for instance, if there is a proposition to amend a section relating to fundamental rights in our Constitution, it must comply with the requirement of Section 9 which require 4/5 of the vote of the members of National Assembly, aside the 2/3 of the Houses of Assembly to say true. This is a special provision to safeguard that provision on fundamental rights is not amended whimsically. The same thing with creation. I will say that even though new states were created, most states that have been created in the history of Nigeria were done during military. From the provision and my reading and understanding of Section 8, it will be an Herculean task for a democratic government to be able to create a state. I will say it is not impossible, but I say the threshold is so high and very cumbersome that it may well be very difficult for the National Assembly and even the INEC to be able to certify that the requirements of Section 8 have been complied with.
That referendum part is going to be a big deal, and like you mentioned. But let's look at the constitutional amendment process. And you've explained to us how difficult it might be for creation of state. Not to say that those who have made efforts shouldn't be hopeful for the propositions they've made. We are in a nation where people can dream, and as such, people can aspire. But give us an understanding about what the process currently looks like. Nigerians are hopeful that if the constitution is fixed, we might have a better nation. But how far with the constitutional amendment process? Are we sure that before the end of this 9th National Assembly, we might have a fixed or an amended constitution?
It's not even going to be the end of the 9th Assembly. I'm very optimistic. By the end of this year, the processes for amendment of the 1999 Constitution would have been concluded. And I say it with all understanding of being actively involved in the process. I'm a member of the Constitutional Review Committee. I represent my state, State of Osun, on that committee. And of course, I've also part of the team set up by Southwest Governors Forum to interface with the National Assembly to ensure that meaningful resolutions come from the exercise. And this retreat that we just concluded this Friday is the second of such retreat that we have had in the past 1 month or so. And notwithstanding that we are currently on recess, we are still going to have another retreat before we resume back. We hope that as early as September or early October, we'll be able to lay a report before the National Assembly. Currently, as at the past 2 retreats, we have considered harmonized bills of the House of Representatives and the Senate, and these bills are quite about 155 or so, in number, and they go through different areas that I believe, if we are able to get the requisite votes at the floor of the National Assembly and the 2/3 in the Houses of Assembly, will be able to make some meaningful injection of relevant provisions that will help in developing governance, also help us in achieving the goal of advancing the welfare and security of our people. I can make allusion to some of the areas that we have looked at and that we appear to have some consensus. On the area of local government, we have come to a position that there's a need to have a constitutional guarantee of a term of 4 years for our local government under a democratic system, and that any local government that is not democratic will not be able to draw allocation from the federal government. This is to ensure that the regime of caretaker arrangement in local government will be done with. Also, the question of funding of local government has also been looked at, and relevant provision to ensure their funding both by the federal and the state government, and insulate dissipation of their funding has also been inserted in the proposed amendment of the Constitution. Of course, the issue of judicial autonomy and apportionment of resources to them from allocations to the state, it has also been looked at, and the distribution of resources under Section 162 has also been amended in this regard. In terms of devolution of power, some items on the excluded legislative list are now going to be on concurrent list, and even in the context of being on concurrent list, they will be bifurcated into area of exclusive legislative competence of the federal government and state government. For instance, if the amendment say true in terms of incorporation of companies, companies that are operating within the confine of a state will only need to be incorporated under the state law. Whereas if it's a national company, then it will be under the national law. Registration of business name will be the business of the state, and of course stamp duties in relation to those state companies and businesses will also come in respect of the appropriate authorities. And we believe that this will free some resources for the state and allow fiscal federalism. So we are looking critically at the exclusive legislative list with a view to bringing some of the items down so that the state will be able to work. And of course, one of the turning issues we are looking at is issue of creation of state police or decentralization of the Nigerian police to address the question of unbundling the security architecture of the country. Even though we don't have a landing yet on this issue of state police, but I believe that there are certain advancements in discussion and getting consensus around creating an efficient and a devolved police force for the country. Of course, other area has to do with issue of magistracy and ensuring that they accorded the recognition as judicial officers in the constitution, because we believe that the bulk of criminal adjudication is done at that level of the judiciary.
On a final note, I'll take you away from the constitutional amendment. Just in the last 1 minute that we have for this conversation, you have a PhD in law, so I always recognize that to get your view on some very turning legal matter. Your party, in the wake of the Ondo State judgment, the Supreme Court judgment, there's been a lot of debates on the leadership of your party and the future. And the World Congress you went into, it does look like it's a difficult time for your party. What's your opinion and your view on what is happening in your party? Just a minute before we go.
We must make a distinction between informed opinion and opinion that is jaundiced or prejudiced by lack of understanding. I've had opportunity of reading the judgment of the majority of the Supreme Court, and I believe they decisively dealt with some of the issues that some commentators are still commenting on. It appeared that some commentators, even though members of our party, are self-seeking in their opinion, and they were not actually seized of the totality of the reasoning and rationale of the Supreme Court decision. And to just briefly summarize what the Supreme Court has said, Supreme Court said the position of the caretaker committee is an interim position, and it does not come within executive position or position deriving pecuniary benefit within the contemplation of Section 183 of the Supreme Court. So as far as they are concerned, Governor Buni and of course my governor, Governor Itola, who is a sitting governor and a member of caretaker committee, have not violated Section 183. And the Supreme Court went further to say that the issue of nomination is not done at the National Secretariat. It's done by people at the Congress of the party. And there was no contention, no argument, and no appeal as to the fact that Governor Akeredolu was emerged as the candidate of our party at the primary solemnly conducted. So the question of whether somebody signed letter in what capacity or the other was considered to be immaterial to the question of validity of nomination. In fact, the Supreme Court went further to say that the requirement for qualification and disqualification of candidates are constitutional, and to the extent that constitutional provisions have been met, there's no basis for anybody to challenge and to succeed in that challenge in that regard. And this is in line with established position of Supreme Court in earlier cases like INEC and Musa, that when constitution has provided for a position, a proposition, any other contrary provision will be inconsistent. Even a repetition of similar provision of the Constitution will be considered inconsistent as to the extent of superfluity. So I believe our party is on a firm ground, and that the commentators are saying otherwise are not informed.
Senator Ajibola Basiru, the Senate spokesperson, thank you so much for your time tonight. I appreciate it.
I'm happy to be here too. Thank you, Sheung.
Thank you.